Today we are going to study law of sea, Mare Liberum, whereas Mare Clausum. Mare Liberum, or The Freedom of the Seas, is a book in Latin and international law written by the Dutch jurist and the philosopher Hugo Grotius, first published in 1609. In the Free Sea, Grotius formulated the new principle that was the sea was international territory and all nations were free to use it for seafaring trade. The disputation was directed towards the Portuguese Mare Clausum policy and the claim of monopoly on the East Indian trade. Grotius wrote the treatise while being a counsel to the Dutch East India Company over the seizing of the Santa Catarina Portuguese Carac issue. The work was assigned to Grotius by the Zeeland Chamber of the Dutch East India Company in 1608. A 1608 portrait of Grotius at age of 25 by Michael Jans van Mierevelt. Grotius' argument was that the sea was free to all and that nobody had the right to deny others access to it. In chapter 1, he laid out his objective, which was to demonstrate briefly and clearly that the Dutch have the right to sail to the East Indies and also to engage in trade with the people there. He then went on to describe how to be based his argument on what he called the most specific and unimpeachable axiom of the law of nations, called a primary rule or first principle, the spirit of which is self evident and immutable, namely, that every nation is free to travel to every other nation and to trade with it. From this premise, Grotius argued that this self evident and immutable right to travel and to trade required a right of innocent passage over land and a similar right of innocent passage at sea. The sea, however, was more like air than land and was, as opposed to land, common property of all. The air belongs to this class of things for two reasons. First, it is not susceptible of occupation, and second, its common use is destined for all men. For the same reasons, the sea is common to all, because it is so limitless that it cannot become a possession of anyone, and because it is adapted for the use of all, whether we consider it from the point of view of navigation or of fisheries. Mare Clausum, Mare Clausum, legal Latin meaning closed sea, is a term used in international law to mention a sea, ocean, or other navigable body of water under the jurisdiction of a state that is closed or not accessible to other states. Mare Clausum is an exception to Mare Liberum, Latin from free sea, meaning a sea is that is open to navigation to ships of all nations. In the generally accepted principle of international waters, oceans, seas, and waters outside national jurisdiction are open to navigation by all and referred to as high seas or Mare Liberum. Portugal and Spain defended a Mare Clausum policy during the Age of Discovery. This was soon challenged by other European nations. From 30 BC to 117 AD, the Roman Empire came to surround the Mediterranean by controlling most of its coasts. Romans started then to name the sea Mare Nostrum, Latin name for our sea. At those times, the period between November and March was considered the most dangerous for navigation, so it was declared Mare Clausum, closed sea. Although bans on navigation were probably never enforced. In classical law, the ocean was not territorial. However, since the Middle Ages maritime, republics like the Republic of Genoa and the Republic of Venice claimed a Mare Clausum policy in the Mediterranean. Also, Nordic kingdoms and England required the passage rates monopolies on fishing and blocked foreign ships in their neighboring seas. Mare Clausum in the Age of Discovery. During the Age of Discovery between the 15th and 17th century, sailing that had been mostly coastal became oceanic. Thus, the main focus was on long haul routes. Countries of the liberal peninsula were pioneers in this process, seeking exclusive property and exploration, rights over lands discovered and to be discovered. Given the amount of new lands and the resulting influx of wealth, the Kingdom of Portugal and the United Kingdoms of Castile and Aragon began to compete openly. To avoid hostilities, they restored to secrecy and diplomacy, marked by the signing of the Treaty of Alcavacovas in 1479 and the Treaty of Tordesillas in 1494. The papacy helped legitimize and strengthen these claims, since Pope Nicholas V, by the Bull Romanus Pontifex of 1455, prohibited others to navigate the seas under the Portuguese exclusive without permission of the King of Portugal. The very titling of Portuguese kings announced this claim to the seas. King of Portugal and the Algarves within and the beyond the sea in Africa, Lord of commerce, conquest and shipping of Arabia, Persia and India. With the discovery of sea route to India and later the route of Manila, the concept of Mare Clausum in the treaty were realized. This policy was refused by European nations like France, Holland, and England, who were there barred from expanding and trading and engaged in privateering and piracy of routes, products, and colonies. In the 16th and 17th century, Spain considered the Pacific Ocean a mere clausum, a sea close to other naval powers. As the only known entrance from the Atlantic, the Strait of Magellan was at times patrolled by fleets sent to prevent entrance of non-Spanish ships. On the western end of the Pacific Ocean, the Dutch threatened the Spanish Philippines. In the 1580s, Spain attempted to settle and fortify the strait to deny entry to foreign navigation. In, in 1603, the seizing of 1,500-ton loaded Portuguese Santa Catarina by the Dutch East India Company led to scandal with a public judicial hearing and a campaign to sway public and international opinion. The representatives of the company then called Hugo Grotius, a jurist of the Dutch Republic, to draft a defense of the Caesar. In 1609, Hugo Grotius sought to ground his defense of the Caesar in terms of the natural principles of justice. Grotius formulated a new principle that the sea was international territory and all nations were free to use it for seafaring and trade. One chapter of his long theory laden treatise, entitled De Jure Priade, made it to the press in the form of the influential pamphlet Mare Liberum, the Free Sea. In it, Grotius was claiming free seas provided suitable ideological justification for the Dutch breaking up of various trade monopolies through its formidable naval power and then establishing its own monopoly. Reaction followed. In 1625, Portuguese priest Serafim de Freitas published the book De Lusto Imperio Lusitanorum Asiatico of the just Portuguese Asian Empire, addressing step by step the arguments of the Dutch. Despite his arguments, the international situation demanded an end to the Mare Clausum policy and freedom of the seas as an essential condition for the development of maritime trade. England, competing fiercely with the Dutch for domination of world trade, opposed Grotius' ideas and claimed sovereignty over the waters around the British Isles. In Mare Clausum, 1635, John Selden coined the term, endeavoring to prove that the sea was in practice virtually as capable of appropriation as terrestrial territory. As conflicting claims grew out of the controversy, maritime states came to moderate their demands and base their maritime claims on the principle that it extended seawards from land. A workable formula was found by Cornelius van Bankershoek in his De Domino Maris 1702, restricting the maritime dominion to the actual distance between which cannon range could effectively protect it. This became universally adopted and developed into the 3 mile limit. Thank you. सुना मेरे को